Good day, Mr. Roland. I'm Loo Ming Min from Taylor School of Law and Governance. So I'm preparing this video presentation to help you, Mr. Roland, in protecting your right in your property in perspective of law. Firstly, let me recall briefly on the case. On January 2023, Mr. Ricky entered into agreement with Mr. Roland for the lease of your workshop, which will be enforced on 1st of March 2023, stated that the rent would be payable 1 year in advance. The agreement was prepared in writing and signed by both Mr. Roland and Mr. Ricky, but was not formalized. However, Mr. Ricky was not able to pay the 1 year's rent in advance, but only paid the rent equivalent to 5 months. Mr. Roland then accepted and allowed Ricky to move his business into the property. So after 5 months, which was on 1st of August 2023, Mr. Roland has been asking Ricky to pay off the remaining 7 months rent to honor the agreement, while Mr. Ricky continued to stay on the property without paying any rent since then, arguing that since the agreement was not formalized, he then is not bound by the agreement. Also, although it was not stated in the facts given, but according to His Majesty's Land Registry, the land register contains more than 26 million titles, showing evidence of ownership for more than 88% of the land mass of England and Wales. Hence, the title of Mr. Roland's workshop will be assumed registered under the Land Registration Act 2002. So, the main legal issue of the case is whether the lease was enforceable to Mr. Ricky. In other words, whether Mr. Ricky is bound to the lease even the agreement was not formalized. So before solving the issue, let me introduce you UK legal system, specifically in law of equity. So equity is supplement to common law, which is based on justice and fairness. The English law of property is a combination of legal and equitable interest. To enforce an agreement in court of law, the agreement must be a formal agreement in which the deed documentation has to be fulfilled according to Section 52, subsection 1 of Law of Property Act 1925. The formalities for the lease are to execute the deed document in order to be valid at law. Hence, in this situation, Mr. Ricky was arguing that the deed document was not executed under the provision. Hence, he was not bound to the informal lease. To solve this issue, I will explain on equity which is applicable in solving the issue. Referring to the case of Walsh and Lonsdale, the case enunciated the doctrine of equitable lease as good as legal lease, in which equity regards that as done that which ought to be done. In this case, Lonsdale, who was the landlord of the mill, granted Walsh a 7 years lease over the mill. The agreement contained a clause requiring rent to be paid up 1 year in advance if demanded, with the rent to be paid quarterly in arrears, as similar in the situation of Roland and Ricky. The parties did not execute a deed for the grant of the tenancy, meaning that the lease was not formalized. The landlord then demanded a year's rent in advance, but Walsh refused to pay. Lonsdale then decided to seize the property to ensure rent is paid in advance. Walsh argued that a lease had to be created by a deed to be legal under common law. Hence, he claimed that the lease was not legal. The court held that Lonsdale can enforce lease against Walsh as under the rules of equity, the parties had created an enforceable lease. Equity was the rules which ought to be applied, notwithstanding the absence of a deed which formalized the lease. This doctrine applies where contract underlying the informal lease complies with Law of Property Miscellaneous Provision Act 1989, in that it is in writing, contains all express terms, is signed by or on behalf of all parties, provides for all consideration, and is specifically enforceable. Applying the doctrine to the case of Mr. Roland and Mr. Ricky, although there was no date of lease, but only agreement of lease. Since the agreement was in written form, contained express terms that the rent will be payable 1 year in advance, and signed by both Mr. Roland and Mr. Ricky, and provided further consideration in which both parties agreed to the rental before signing the agreement, and the agreement was specifically enforceable. Hence, the lease was considered as equitable lease, which will be given the shape and form of the enforcement of a legal lease in which equity steps in and treat the equitable lease at law as being as good as legal lease under the rule in Walsh and Lonsdale. Hence, the outcome will likely to be that Ricky will be bound by the lease and Mr. Roland is entitled to claim the remaining 7 months' rent as the lease was subjected to the terms of executory lease agreement, or if Ricky refuses to pay, he has to leave the property. Regarding this statement, the challenge that Mr. Roland may face is Mr. Ricky may raise a defense by arguing that the agreement was unenforceable, since the intention of the agreement was to create a lease that would be valid at common law. However, referring to the case of Parker and Teswell, it was held that the agreement could take effect in equity, and the relevant legislation did not lead to a contrary conclusion. Hence, Ricky will be likely to be bound by the lease, and the next challenge that Mr. Roland may face is regarding to the acceptance of partial payment of 5 months' rental. Mr. Ricky may raise defense claiming that implied periodic lease arose by virtue of the payment and acceptance of rent, so that it was entitled to determine such a tenancy by notice to quit. However, the intention of Mr. Roland to accept the payment is not that he intended a periodic tenancy to receive rental on 5 months interval. Yet, Mr. Ricky only paid once. Hence, the lease should not be considered as implied periodic lease. Hence, the Roland is entitled to demand the remaining 7 months rental as in the initial agreement, or Mr. Ricky has to leave the property. While in common law perspective, we can refer to Section 54, subsection 2 of Law of Property Act 1925. The provision stated that leases with terms not exceeding 3 years can be created simple by oral or written agreement, but must take effect in possession and at the best rent which can be reasonably obtained without taking a fine. Applying to this case, the lease was less than 3 years. Mr. Roland did allow Mr. Ricky to move in for his business, yet Mr. Ricky was staying in the property. And since both parties agreed on the rent before signing the agreement, hence it could be said that the lease was at best rent. Hence, the lease in this case was considered as legal lease under common law. Also, we can refer to the case of Jawad and Akil. In this case, the landlord allowed the tenant to live in his property on payment in advance for 3 months, expressed in a receipt. While the parties negotiated on the lease but never reached the agreement, the landlord then sought possession, claiming that the tenant was in occupation as tenant at will. It was held that the tenant had a mere tenancy at will, since the tenant's possession with landlord's consent together with payment and the acceptance of rent by quarterly payment did not raise a presumption of periodic tenancy. The fact that the parties were negotiating for a final agreement indicates that the granting of possession is just a temporary measure and quarterly payments are in anticipation of the terms to be agreed upon. Importantly, a tenancy at will can be revoked at any time by the landlord. In short, a tenancy at will is a tenancy under which the tenant is in possession, and which is determinable at the will of either the landlord or the tenant according to Halesbury laws of England. So, a tenancy at will arises when the tenant is in occupation but the parties are in the course of negotiations. In the case of Mr. Roland, The decision made by Mr. Rowland to accept Ricky to move into the property with 5 months rental payment considered as the will of Mr. Rowland. But it is a temporary measure since at that time, Ricky was not able to pay 1 year rental in advance due to the spending for medical expenses. After 5 months, Mr. Rowland asked for the remaining 7 months rent, and Ricky refused to pay any rent since then, but continued staying on the property, showing that the final agreement was not reached. Hence, Mr. Ricky was being considered as in occupation as tenancy at will. A tenancy at will is determinable by either party of his expressly intimating to the other his wish that the tenancy should be at an end. Hence, Mr. Rowland has the right to revoke the tenancy at will as a landlord of the property to let Mr. Ricky to leave his property by expressly intimating his wish to Mr. Rowland, or Mr. Rowland may need to consider legal actions if Mr. Ricky refuses to do so. The challenge that Mr. Rowland may face under common law is Mr. Ricky may argue that a notice to quit is necessary before Mr. Rowland demands the possession of the property, which is stated in Section 25 of Landlord and Tenant Act 1954. However, since the definition of tenancy in Section 69 subsection 1 requires some form of agreement which does not apply to a tenancy at will, hence Mr. Rowland is entitled to demand Mr. Ricky to leave the property on his wish to end the tenancy at will. In conclusion, since equity prevails over the common law, so that there cannot be two estates, hence the tenancy at will give away to the equitable lease on the same term as informal agreement between Mr. Rowland and Mr. Ricky. Mr. Rowland can choose to take legal action to enforce the original agreement and ask Ricky to pay the remaining 7 months rent in advance, or you may try to negotiate with Ricky to find a mutually agreeable solution considering the circumstances. Thank you for watching, Mr. Rowland. I hope this video helps you make an informed decision regarding your lease agreement with Mr. Ricky.